Okay. So first of all, thanks very much to the organizer for having me today. It's a great conference. I'm very, very happy to be here talking. And of course, this conference is called Policy Responses to New Forms of Work. We have heard about also non-standard forms of employment throughout the day, casual work. And now we're going to talk about self-employment. Of course, the problems with collective voice when it comes to non-standard forms of employment are not confined to self-employment. There are many issues that signal that non-standard workers, so workers that have a relationship that is different from the standard open-ended employment relationship, have problems in unionizing and having access to collective bargaining. One of the main issue is with subcontracting, with agency work. In many cases, they don't know whether they can bargain collectively with the principal or the user firm or the agency. In some cases, this is established in the law. In other cases, this is still a problem. Now, of course, we don't have time to go into all that. I will just say that in 2016, the ILO published a report on the standard forms of employment that also tackles the issue of difficulty in collective rights for the broader spectrum of non-standard work. So today, I'm going to concentrate, and I also wrote an article on the Industrial Law Journal in which I delved more in 2017 on collective rights for non-standard employment. So I'm not going to go broadly on this. I'm only going to concentrate on self-employment, but there's much more out there. Now, when we talk about self-employment, we are actually seeing a trend in which self-employed workers or people who are classified as self-employed try to organize, try to enter into unions, or the unions try to reach out to them. And this, we can see that more than in the past. We've seen efforts from traditional unions, but also efforts from self-employed workers in unionizing that wasn't so present only a decade ago. But the issue is that this interest is not very well corresponded in current regulation and practices. When it comes to self-employment, and especially if we talk about some very vulnerable forms of self-employment, especially if we talk about bogus self-employment, or if we talk about platform work, we see that workers it's very easy to discontinue the arrangement of these workers. When it comes to platform work, if you don't want a worker to work with you on the platform, the only thing you need to do is to discontinue, to deny access to the platform. So it's very, very easy to exclude them from the platform, to dismiss them. And this is very similar to what happens already with casual work. If you don't want a casual worker anymore, you just discontinue, you zero their contract, you don't call them in the future. So there's it's very, very easy, and it has always been there with temporary forms of work, that when you don't want a worker anymore, you don't need to fire them. You can just discontinue the contract because the term is not renewed, or there's no prorogation, or you are able to disconnect them from platforms, or it's very easy to discontinue 0 hours work, for instance. And this has an impact on the possibility of these people to unionize, because in many cases they are scared of going and having recourse to unions. They are scared to engage in collective action. They are scared of engage in collective bargaining because they are afraid that their contract will be not renewed, or they will be excluded from the platform, or their hours will be zeroed down. And the thing is that in many countries around the world, we have provisions that protect workers, employees, from discriminatory dismissal for union reasons. If you fire somebody because he's a member of a union, in most jurisdictions around the world, that's a discriminatory dismissal that triggers strict sanctions. Now, the point is that this does not extend to a discontinuation of a fixed-term work, to zeroing down working hours of casual workers, or to disconnecting a platform worker from the platform. Because the law doesn't treat in the same way, in many cases, a dismissal and doesn't equate all these activities of discontinuation of vulnerable workers to a dismissal for union reason. And this is something that I think should be addressed. But then, other than that, we see that when unions try to reach out to self-employed people, or the other way around, that self-employed try to organize in traditional unions or in grassroots organization, in many cases, you have to overcome many practical difficulties. The union must invest a lot of resources into that. To organize a collective bargaining with these workers is quite difficult because they are not concentrated in the same place. You need to invest a lot of time and money into these processes. And in some cases, what happens is that when you do that, antitrust authorities step in and say, wait a second, self-employed persons are not supposed to bargain collectively because if they do so, they engage in a cartel. They violate competition law because they are considered to be under current antitrust standard undertakings, independent on the market. And if they bargain together to fix a price, they're actually engaging in anti-competitive behavior. And therefore, it happens that collective bargainings signed for self-employed workers such as musicians or artists, actors, in Europe have been declared null and void by antitrust authorities, or their negotiation activities have been stopped because antitrust authorities said this is actually engaging in anti-competitive behavior. And we had a very important case in the EU about substitute musicians that had reached a collective bargaining agreement in the Netherlands. And this went up to the Court of Justice of the EU that actually said only false self-employed people can bargain collectively. Self-employed people are not supposed to do so because doing so will breach Article 101 of the Treaty on the Functioning of the European Union that bans anti-competitive behavior. The problem is when we look at the judgment from the ECJ, from the Court of Justice of the EU, is that it's not very clear how do we regard false self-employment. Because in some paragraphs of the judgment, the court used a definition that is based on direction. So people who work under the direction of someone else are to be regarded as false self-employed, and therefore they can bargain collectively, and all the other people are not, and they cannot bargain collectively. But saying that somebody who is in the direction of someone else can bargain collectively is nothing new, because that's the definition of who an employee is. An employee is somebody who is directed by someone else. And self-employment normally is defined as a relationship in which this direction is not present. So if you say only the people who are directed by someone else are false self-employed, you are basically saying a truism. On the other hand, there are also other paragraphs of the judgment that are more interesting, in which the court says you actually need to be independent on the market, and you can be in a comparable situation to employees. That means that you don't necessarily have to be identical to an employee to be regarded as a false self-employed. But the problem is that at the moment, it is not very clear under EU law which part of the self-employment is allowed to bargain collectively. And this has an effect of freezing the activities of unions and in engaging in collective bargaining on behalf of the self-employed. Now, the question of antitrust and restriction from antitrust to self-employed activity and self-employed and collective bargaining for the self-employed has also been brought before the ILO supervisory bodies and the Council of Europe supervisory bodies. And under those standards, self-employed persons are to be allowed to bargain collectively. And you can restrict the activity of bargaining collectively if there's a good reason for doing so, but you cannot start from the assumption that all the self-employed need to be prevented from bargaining collectively. So there's also a problem of clashes between standards at the international level here. What happened in Ireland was interesting because Ireland was one of the countries in which basically the activity of collective bargaining in favor of self-employed persons was regarded as in breach of competition law. And therefore it was frozen for a number of years. The case arrived until the ILO Committee on the Application of Standards, and it's also now under discussion by the European Committee of Social Rights of the Council of Europe. And what happened in Ireland was that basically Ireland introduced a new regulation in the Competition Act and provided that self-employed people who are fully dependent on a principal or a limited number of principals can be allowed to bargain collectively. There are some categories of people like musicians, actors that are allowed to bargain collectively ex lege, and this immunity can be extended also to other forms of fully dependent self-employed persons if they prove that these workers have fewer than 2 principals, and if they prove that this is not in breach of EU law and that the impact on the market is non-existent. Now, proving this before being admitted to collective bargaining is basically a very high burden of proof. It's extremely difficult to be admitted to collective bargaining if you have to prove all this. And imagine if you have to do that before starting to reach out to the people that you want to organize. So this is actually still quite a restriction on the right to collective bargaining of self-employed people. Now, since we are discussing what governments can do to help self-employed people to express their voice, I think there are 2 things that could be examined. The first one is to extend anti-discrimination provisions and this anti-discrimination provision against unionization to self-employed persons. Freedom of association is a fundamental right, is recognized under many instruments around the world, and therefore cannot be restricted only to employees, because that would make a fundamental right and a human right under many treaties dependable on your employment status, and that doesn't make sense even from a theoretical perspective of what human rights are. Self-employed people are still human beings, as far as I know, so they also should enjoy the human right to freedom of association. If you're not free to join a union because you are scared that if you do so, you might be retaliated against and you don't have recourse in discrimination, then your right to join a union to freedom of association is not fully respected. And when it comes to collective bargaining, again, in a number of international instruments, collective bargaining is seen as a fundamental corollary to freedom of association. You cannot have meaningful freedom of association if you also don't have the right to collective bargaining. This is true under ILO instruments, but it's also true under Council of Europe instruments. It's true under a number of constitutional traditions of also OECD countries. Now, if we say that collective bargaining is a fundamental right, in order to restrict that right, there must be good reasons for doing so. So it is on those who want to impose a restriction the need to prove that actually there are good reasons for doing so. You need to prove that there is actually a big impact on the market to restrict the right to collective bargaining. You need to prove that the workers you want to prevent from engaging in collective bargaining are actually independent as true undertaking on the market. Otherwise, you should be presumed in law to be allowed to collective bargaining. Otherwise, we are not taking the right to collective bargaining as a fundamental right seriously. And we should at least say that openly if we don't want to do so. Thank you.